Hey there. How's it
How are
going?
you? I'm good. How are you?
I'm great.
That's good.
So, what about the last week? How's it been?
It's been good. I find working from home has its challenges. Just my dogs bark a lot, and then I've got
Yeah.
both my kids here now, and it's distracting and it has its challenges, but it has its good points too. So, how about you? How are you finding it?
You know, um, First of all, I've been very efficient at home. So, I set up my computer, my laptop, my printer, it's Bluetooth connected. Um, there's been a ton of webinars from so many organizations, some to do with law, some to do with family law, some to do with mental health. Um, all of the different changes from Canada Revenue Agency, and there's been a lot of those webinars. So it's been, quite frankly,
Oh,
before
I think his
COVID.
connection there is.
Can you hear me?
Oh, yeah, I can now. Your connection kind of faded out
Oh, I
for a
see.
couple seconds there.
I see. Anyway, so yeah, so the last couple of weeks have been a learning curve for all of us, but also for us
For
lawyers
sure.
because we're advisors. So how can an advisor advise on topics where there hasn't been previous education on? And not only that, things are changing in real time. So here you are advising
Exactly.
while we're getting publications from the CRA and from the courts on what it is that we're supposed to be advising people on. So it's actually quite interesting.
Yeah, I find it's challenging because things are rapidly changing, and even yesterday the courts put out like they have new things that it's not, that they're taking new types of cases. It's not just the urgent ones, although that's kind of primarily
Right.
what it is. But there was an expansion, and it's different in different jurisdictions, and it's just staying on top of it all because I don't know about you, I have clients who are in various jurisdictions all around the GTA, and it's different, say in Brampton versus Newmarket or Toronto, and so
Yeah.
just making sure I stay on top of all that. That has its challenges.
Yeah. So actually, this is where balance and sort of body and mind connection and eating healthy and sleeping well comes in, because as things are coming at us really fast, you gotta remain zen, and you gotta be able to be the voice of reason to clients
Yeah,
who are looking to us to give them. And even when we don't have the answer, we have to be able to say, okay, I don't have the answer, but if there are three or four different possible answers, let's weigh the one that makes most sense for you. We'll never really know if that was the best answer, but it was the best answer at this moment for you.
exactly. And I find, people going through divorce and separation, that's a stressful time, even at the best of times. So when you add in the whole COVID-19 situation, I find a lot of my clients are, their stress levels through the roof. So I see my role, is to be the voice of reason, to stay calm. Sometimes they need to vent with me, and that's okay. But to just stay calm, guide them, and make sure that they know that things are going to be okay one way or another when all this is done.
Yeah, exactly. Okay, so I think we're ready to roll right into the subject.
I think.
I'll let you introduce it.
Okay, so our topic for today is how COVID-19 is affecting property settlements in a divorce, which of course relates to the equalization payment and that sort of thing. So the first question I have for you, Steve, is separating during COVID-19 a good thing? Are there advantages to separating right now?
So, in order to answer that question, you and I know what the backdrop of the law is in Ontario. But I think some of our viewers need to be reminded why your question is even being asked. And the answer is because under Part 1 of the Family Law Act, which governs property division for married people in Ontario as a result of separation, that law says that the date of separation is the date that is used to value the assets and the debts for the purposes of property division. and what we call equalization of net family property. So if a couple split up on January 1, 2020, that was the date that husband or wife said to the other one, we're done, we're breaking up, you know, let's go to mediation, let's go our separate ways, I'm sleeping in the other room, or I'm moving out, whatever the way it came about was, but it came about on January 1. By virtue of that, all of their assets and debts that are in each person's name is going to be valued at that date, not the day before December 31, not the day after January 2, but on January 1, 2020. And that is the date that's going to be used in order to calculate all the numbers for the purposes of property division. Now, just so that we're clear, that does not affect assets that are in joint names or debts that are in joint names. That goes, that clock keeps rolling forward until the date that that joint asset is sold, divided, and so forth. So we're only talking about assets and debts that are in one person's name that is predicated on the date of separation. So if...
Does that include the matrimonial home? Because I know a lot of people, you know, might be unsure about that.
Right. So there are cases where the matrimonial home was deliberately placed in one person's name. And there are cases where the matrimonial home was put in joint names. So if it's in joint names, the date of separation is less important. It's quite frankly unimportant, because they might split up 2 years ago, but they're still living in the house or holding the house. And then they're going to deal with the sale of it or maybe the buyout on some of the date if it's joint. But if it's in one person's name, then in that situation, then there is an argument that the date of separation determines the value of the matrimonial home for the purposes of property division. But there has since, certainly in the last, I think it's about 7-8 years ago, there is the Court of Appeal in Ontario issued a case that basically stood for the proposition that even if the spouses place the property in one person's name for the purposes of, say, creditor protection or debt avoidance, that the asset itself is being held by that one person in trust for both spouses, in which case it treats it almost as though it's a joint asset. So back to your question, Leanne. Should spouses who were considering breaking up prior to COVID break up during COVID? First of all, that answer is mainly a psychological and emotional question. But what are the implications if they were to announce to one another their intention to break up during COVID? And the answer to that is that because the assets are divided based on the value of the date of separation, therefore, if a couple, for example, had $1 million stock portfolio in the wife's name a month ago, and as a result of COVID, that $1 million portfolio is now worth $600,000 because the market has gone down, and they split up today, they are equalizing a $600,000 asset. They're not equalizing the $1 million asset that just existed a month ago. And if they split up 6 months from now, when that $600,000 asset rises back up to $750,000, then they are going to equalize $750,000, because that would be the value of the asset on the date of separation. So there are cases where people had been planning on splitting up, but they just didn't actually take that final step of announcing it and declaring it and then acting on that. And just so we're clear, it's not just saying it and then behaving differently. It's saying it, meaning it, and behaving that way. That's what the cases all say. If they actually today declare, I'm splitting up, I'm sleeping in another bedroom, I'm not going to have dinners with you, we're not going to have romantic relations anymore, we are done now. Today's the date of separation. That needs to be declared, generally committed to in writing, maybe a letter from a lawyer. And with all that said, then the A date of separation is the date that you've declared it, and the assets are going to be valued and divided. And don't forget, not the joint assets. We're just talking about the assets in individual persons' names and the debts in individual persons' names. So what do you think about that?
Well, I think it depends on the circumstances of the client as to whether it is wise to separate during COVID-19 or not. Because if you're the client who has perhaps a business that has now been, shut down by COVID-19 and perhaps irreparably, maybe it's not even going to come back, so that value's gone down dramatically. This may be a time when you want to separate because the equalization on that business is going to be much lower, or there won't even be one if the business has completely lost any value. But if you're the partner, so if the partner of that person is my client and they were hoping to get an equalization of that business, then I would be advising them that this is not the best time to separate, that they are better off to do it, to wait a bit until hopefully the business comes back and the value, recovers as the economy recovers from all of this. So I would advise them to hold off. So I think it really depends on the person's circumstances. So much of law does, as to, whether it is a good time or not to separate right now.
And what the viewers have to understand is the triggering of a separation does not require mutual agreement. So if wife says to husband tonight, we're done, we've been having problems for 2 years, they've never been rectified, and I am now done. And husband says, no, I really don't want to break up. I'll change, we'll go with counseling. And if the wife says, I've made my decision, we're done, it doesn't matter that the husband says, I don't agree. So it only takes the one of two people, and by the way, sometimes it's both, but it takes at least one of two people to say, we're now done. And then the next step, of course, is to confirm that in writing so that it's never debatable. And I've told people in the last few weeks that the best way to do that is to have a lawyer write a letter saying, I've been retained by so-and-so. She or he has indicated that you two separated today or yesterday, and we will now be beginning the process of exchanging financial statements and disclosure in order to begin the process of calculating everything. Something very very shallow, but just to basically point out, we have now confirmed a separation.
No, and I think that's so important, because I have had clients where in their mind, they felt they were separated, they felt they were acting in a certain way, but potentially to an objective observer, or certainly to their spouse, they were not. And, I always say it, you have to do something more than just think in your mind, that you're separated. And a letter from a lawyer is obviously a very good way to make sure that it's abundantly clear, so that there is no issue, because that is something that people sometimes try to play around with as well, because it can affect valuations. And so when it's not necessarily clear, you may find that your ex-spouse is trying to use a different valuation date that's more favorable to them. So you want to make sure that that doesn't happen.
And some have asked me in the last few weeks, well, we're self-isolating. How can we separate? It's almost antithetical. In fact, I read an article of a couple that previously separated, and because of COVID and because of self-isolation, the ex-husband moved back in with the ex-wife in order to be around the kids all the time. So it's a very interesting concept. How do you separate while global governments are forcing people to remain together? And so it's an interesting concept, but the fact of the matter is, we actually, on this one, we actually have case law. We have case law that tells us what are the factors that guide judges, lawyers, mediators to determine that a couple actually did separate. And obviously the letter from the lawyer, that's a no-brainer. We've already covered that. But you can't just have a lawyer write a letter and then it's business as usual tomorrow morning. And they're sleeping together and they're Zooming other family members together and they're doing Easter and Passover together. So the behavior has to match the words. And if the words were separated, the behavior, whether that means sleeping in another bedroom, whether that means no longer having relations, whether that means communicating to the general public, to the family and the friends, you know what, me and my spouse are now separated. That is the evidence needed to establish, even during self-isolation, that there was a separation.
Yes, those things are all important, and they can still be established in self-isolation, because you could still not be sharing a room. You could still be not eating, at the same time or sitting down as a family. You could still, when you're talking to family and friends on the phone or via Zoom or however you're communicating with people outside your home, you could be making it known that you've separated. So you can still do all of those things during this time when you're self-isolating.
That's right. One thing I want to also point out is that under the Divorce Act, which is the act that we find the date of separation. Why? Because in order to get a divorce in Canada, one of the three different bases for a divorce, there's adultery, there's cruelty, but the one that's most common is a 1-year period of separation. So we have statutory law that deals with the counting of 365 days. So the 365 days to qualify for divorce starts from the date of separation. The reason I mention this is because there's an extra subsection there that says if they reconciled and resumed cohabitation for 90 days or more, that clock starts from the beginning again. And so there is case law that says, well, they did split up, for argument's sake, today, but then they reconciled and they stayed together for 100 days. What's the date of separation? It may very well be, the clock might very well have started again. So people need to be aware of the fact that you got to do what you say and say what you do and then stick to it. Otherwise, if the approach they're taking is that I'm separating now, then that approach might very much be undermined if there's a reconciliation and then a later separation. Yes,
no, that's very true. I think now might be a good time to move to our second question, which ties in a little bit with what we were talking about. But we're going to chat about what happens to the division of property if values have plummeted as a result of COVID-19. So say a couple was working out, they've already separated. Maybe they've done financial statements even with, with the valuation date and everything. And then now the values are plummeting or have plummeted with the home, with businesses or whatever. How will that affect, is somebody stuck with the valuation date on the separation date? Or, are they going to have a remedy given the current situation?
Let me start by saying this is extremely common. So if 50% of marriages break up, and I and you have dozens of cases that are active right now, think about the number of Canadians right now, the number of Ontarians right now that actually were in queue to have a divorce settlement, and then COVID came. So they separated before COVID. They may have separated by living in different homes or moving into the basement or still living together, but they already separated and they already established a date of separation and therefore a valuation date for the quantification of their assets. And in many of these cases, those assets, whether they are stock portfolios, real estate in one person's name, or businesses, and that's the big one, by the way, the businesses.
Yeah.
Because a lot of these businesses, most of them have been devastated. Yeah. Even with all of the government COVID relief packages, with the wage subsidies, and with the emergency relief programs, and the $40,000 loans, and so on and so forth. So even with all that, many businesses have really been affected by COVID. Some of them will, resume and go right back up, and others may never actually come back. And so I've got clients in many different industries, and many different fields of work, who are owners of their businesses, or of their practices, depending on what you're talking about, that have been very much affected by COVID. And so for those people that already separated and they thought they had a value for whatever their portfolio, their bank balance, or their, sorry, let's focus really on things that may have actually not been touched. So like a stock portfolio or real estate or a business. So in those cases, the value in most of those cases has gone down, and in some cases significantly gone down.
Yeah.
And so we as lawyers have to turn to what we know best. And what do we know? We know what the law says, and I just explained it a few minutes ago. It's the data separation value. There's a but. We have one case from the Court of Appeal from 2009, 11 years ago. And that case involved a couple that split up. And when they split up, the husband owned a textile business. And his textile business was worth somewhere around $9 million. There was a valuation, and everybody was good with it. It was worth $9 million when they split up. By the time they got to trial, his business tanked for no fault of his own. The industry shifted, and the value of his company went from something like $9 million to something like $4 million.
Yeah, it went down 50%.
And the trial judge did exactly what I just explained a few minutes ago. Said, look, the law is the law. Then the value is $9 million. You owe, after all is said and done, something like $4 million. And the guy's like, well, hold on a second. The business isn't even worth that now. And I'm going to pay more than the value of my current business in an equalization payment. So that man went, by the way, it was the case of Sarah and Sarah. For those that want to read it, it's SERRA, Sarah and Sarah, and it's a 2009 case. And if you go to www.canlii.org, CANLII.org, you could click on Ontario Court of Appeal and read the Sarah case. And I'm going to read you a little clip from the Sarah case. But in that case, the judge did something extraordinary. When I say the judge, I mean the Court of Appeal judges did something extraordinary. They said, you meet the test of a technical subsection of the Family Law Act that says if payment of an equalization payment based on the valuation date is unconscionable, shocking to the conscience, it's unconscionable to pay that sum, then the court can deviate from the 50-50 split and provide a different number that's possibly based on the current value. And so in that case, it's the Sarah and Sarah case from 2009, where, and I'm just going to read you a couple quotes from it. The husband's principal asset at the time of separation was his shareholding in a profitable textile business valued at between 9.5 and 11.5 million. The wife made a claim for a share of the property. By the time of trial, the value increased by approximately $8 to $9 million, entirely as a result of the shifting market forces that adversely affected the Canadian textile industry. And in closing, the court wrote that the market-driven valuation date change in the value of the spouse's assets may be taken into account in determining whether the equalization payment is unconscionable. And in that case, the court did find in favor of the husband in the Court of Appeal. They found that it was unconscionable, and they decreased the amount, and he went from owing what was going to be, I think, around it was going to be 4.1 million, and the Court of Appeal dropped it to $900,000 based on the fact that the market forces, not his own behavior, the market forces caused the valuation to drop, and he only had to pay her $900,000, which was much more sensible. And so we don't know what's going to happen with COVID-related claims like this, but unlike so many other questions that we have not had the answers to, this is one that we actually have something to look at.
No, and I think it's going to depend on, I think, how long this goes on for and how long it takes to recover from. Because in the Sarah case, one of the things the Court of Appeal did mention was that it has to be something more than just, kind of an ordinary recession that, does happen from time to time, over periods of time. And so, if it's just a simple situation of, a few months we're in a recessionary period and, maybe the business went down or a stock portfolio went down, I think a client might have a more difficult time arguing that it meets the requirements for it to be unconscionable for there to be an equalization. But in something like COVID, if, for example, if you operate a restaurant and, you've been shut, you're not doing takeout or delivery and you've been completely shut down, and you're not able to, you open up again in, say July or August, and then there's a second, round of this, and you just don't recover from it and go right out of business. I certainly, if I had a client in that situation, I would be doing my best to put forth the argument that it would be unconscionable to have, that value, that whatever value it was in February or January of this year.
Yeah. I've actually,
if it bounces back in August, then, that might be harder to say that, because if it's going to bounce back and go, by the end of the year, even be up to what value it was at the beginning of the year, which given the current circumstances, I don't know how plausible that is, but, say that happened, then I think it would be harder to establish that, an unequal division, would be necessary and would meet the test of, or that an equal division would be unconscionable.
Well, let me ask you this. Many of our cases where we represent a couple that there's a business in the family, we can't solve the divorce without evaluation of the business. Whether the business is a professional practice like an accounting practice or a hair salon or a florist design company or a manufacturing plant or a retail store. So let me ask you this, Leanne, in your situation, if you already have valuations of companies that are part of your divorce clientele portfolio, and you've already determined the value of whether it's 6 months ago, a year ago, 2 years ago, what are you going to do with those valuations? Are you going to rely on them? Are you going to get new numbers? What's your plan?
I think, and I hate to say it because it's such a lawyer answer, but I think it depends. I think it depends on the business. I think it depends on, if it's a business that's been around for a long time and it's had, its ups and downs, with market fluctuations and recessions and things. And those kind of things have been looked at and factored in because there's this period of history that can be looked at. That might be different than a newer business, like some tech business or something that really took off and then somehow has been, dramatically impacted. So I think it really, for me, it depends on the specific situations of the clients, what type of business it is, and all of the factors, that come into play as to whether in some cases, I might want to get it. I might recommend a new valuation. Maybe it won't have, because it's just a kind of a mini valuation because you already had the previous one. Hopefully it won't be as costly to the client as business valuations can be. But in some cases, I would say it might not be necessary. So it's really going to be specific to each client situation. How about you? Do you have clients in that situation, and what would you tell them?
Yeah. So first of all, I'm not looking to spend any of my clients' money right now. They don't have any. They're struggling, and we're not going to spend money on another valuation while we are in a state of flux. But if we are having this conversation after COVID has passed, vaccines or treatments have been confirmed, applied, and the global crisis is now over, we are going to now re-examine these divorces that are in flow, that are in progress. We're going to look at those analyses, and then I'm going to have a conversation with the appraiser. And I'm going to say, what were the underlying factors that you looked at? And if any of the underlying factors have been significantly modified perpetually, chronically, irreversibly as a result of COVID, then it may very well be to spend the money on another valuation. But I'll give you an example. For example, I've got clients that are a dentist. Well, they've been closed for 3 weeks. They're not seeing patients. They've issued ROEs to all their staff. But we all know that once the crisis ends, those dental practices are going to reopen, and they would have suffered an aberration of revenues, whether it's for 2 months, 3 months, 6 months, whatever that number is. But the value of the actual practice is unlikely going to be different, because it's unlikely the case that all of the patients are going to go to another dentist. So
there'll
those
probably be a
patients,
flood of them coming in that didn't get their checkups on time, wanting, you know, in the initial period, maybe they're even going to be working longer hours to make up for it.
and that goes to revenue, which is indirectly relevant for the purposes of valuing the dental practice. But if the dental practice was valued at $1 million 6 months ago, it's unlikely that that dental practice is going to be worth different 3 months from now. It's what's going to be different is the amount of support in the period from then to now. But will the value actually be different? No. But on the other hand, we've got lots of clients who are retailers. And I don't know about you, but in the last 3 weeks, I've become really, really good at online shopping.
Me
and
too.
So will I yearn to go to Yorkdale in the future? Maybe on occasion, but you know what? I'm going to think long and hard about getting something that requires me to get in the car, drive and park, walk through a mall, buy it, put it in the car, bring it right back home, when all I have to do is go online with a couple clicks and it's at my door tomorrow. And so some retailers, where they had a valuation of 6 months ago, those retailers, the ones, by the way, that survived, will likely have a different value of their business. The question is, what is the new value? And the answer is going to be, it's going to be based on the new numbers to be determined.
Yeah. Because I think some businesses, like you mentioned with the dental office, there's certain types of businesses where once this is over, people are going to come back and it's going to rebound. But there's other types of businesses where, you know, even, for example, with, say, personal trainers or services like that, you know, people may get used to working out on their own or using online options, and they may not return to some of the personal trainers when COVID-19 ends. And so I think, you know, there are businesses that could be irreparably, you know, harmed and will not bounce back. And that needs to obviously be taken into account with valuations.
Let me ask you another question. You know, in the last few weeks, the Trudeau government has not only copied what other governments have done, but they've done a good job trying their best to help not only employed people that lost their job, but self-employed people not only have some form of revenue. As we know, the Canadian Emergency Relief Program is in place, offering the benefit of $500 a week, at least for the next, I think it's 3 or 4 months. But we also have the line of credit that is established. At this point, they say the $40,000 might be the $40,000 credit line. 25% of it might be forgiven. So we've got all of these different, and then we've got the remittance, the wage subsidy remittance reduction of 10%, and we've got GST and HST. We've got taxes being deferred. So when you look at all that, is that going to actually cause us as lawyers to then challenge the business owners and say, look, with all of that relief, did you really suffer? Or are you just using this as an opportunity to try to redo your divorce settlement or to get a better deal? What do you think about that?
Well, I think that that's an argument that can be made, and there will be certain people who will do that. There'll be lots who, you know, are legitimately in a situation where a value should be, you know, changed due to the circumstances. But, you know, there's always going to be people who try and take advantage of the situation. So there will be spouses out there who do that. The other thing too, with all of this happening, that I think could impact businesses, you know, in a longer point in a longer horizon, is that there's always going to be a day of reckoning. So I feel like, right now there's all the, things being deferred and loans and, this and that, but it's not, free candy or something like that. I mean, at some point, individuals and businesses and taxpayers and, all of that are going to have to pay back, these things. So, if you're deferring your lease payment, during COVID-19, it's not that you're being forgiven, for those payments. And so my concern as well with some of the businesses is that when all this is over, they may have a lot of costs, for paying back some of the things that they've, the breaks that they've had or things that they've done during this crisis that will also impact their revenues, in the longer horizon.
Yeah, on the subject of this valuation date issue and the value of the asset and so forth, there's a lot of questions, because if a business's revenues have gone to zero, but as a result of the layoffs and as a result of non-payment of rent, potentially non-payment of rent, maybe their cost base has gone down. And if you're a restaurant and you're not paying rent and you're not paying your staff and you're not incurring any of your variable costs, like for example, for food, wine, alcohol, that sort of thing, then you gotta look at this under the microscope, and you can't just make a global sentence and say, hey, all businesses are affected or all restaurants are affected, because in some cases, I have clients that are landlords, they're not collecting the rent from their restaurant tenants. So if the restaurant isn't paying rent and the restaurant is not paying for staff and they're not paying for food, I'm not saying they're doing well, but maybe they're not doing as badly as we might believe they are doing. And that when they reopen, if they've got a long-term relationship with their clientele and their customers come back to them, and they may very well come back to them in the exact same way they were before, or they might come back to them even more, because there's been all of these social media posts about supporting your local community. Will people then sort of one up what they did before in order to support their businesses? So it's a real question mark as to what will happen in this respect.
Yes, there's a lot of things like, we don't have a crystal ball, so we don't have the answers to. And I think we're just going to have to wait and see how this whole thing plays out. Each case is going to have to be looked at on an individual basis. I don't think there's going to be, there's one set of rules per se, but how it's applied is going to be very fact specific.
How are we for time?
You know what? I think we are 4:34, so we're pretty good.
Excellent. Excellent. Well, this was a lot of fun, Leanne. Thank you. And we have to come up with another idea for next week's webinar.
Yes, sounds good.
Thank you so much. Be well.
Thanks everyone for listening.